Chair recognizes the gentleman from Whitley for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. I'm here to present Kimber's Law, House Bill 249, which would make murder of a child under the age of 12 an aggravating circumstance. Before I dive deep into the explanation of the bill, I'm aware it's a serious topic. It may take a few minutes, and I want everyone to keep in mind that this is not necessarily a vote of approval or disapproval of the death penalty. It is more nuanced than that, and I hope to cover that today. Under KRS 532.020, the penalty for a Class A felony is 20 to 50 years or life with the possibility of parole after 20 years. The intentional murder of a child under the age of 12 is a Class A felony. Under 532.025, there is a list of crimes that we have decided to label as aggravating circumstances. Those are 8 crimes, and the penalty range for those are 20 to 50 years, life with the possibility of parole after 20 years, and then the added life with the possibility of parole after 25 years, life without parole, and the death penalty. There are 8 aggravating circumstances. I will succinctly describe those. Of course, there are paragraphs in the statute, and this is a bit of shorthand. But first, the person committing a murder has a prior murder conviction. Second, the murder occurs during the commission of a violent offense such as burglary, robbery, or rape, or arson. Those are crimes that you would see that are aggravating circumstances that tend to happen out in the real world. There are some that are less common. Number 3, the murder using weapons of mass destruction. 4 is if someone is hired for murder, a hitman situation. 5, a murder of a prison employee by a prisoner. 6, the murder of more than one person at a time. That's another that does happen out in the real world. 7, the victim of the murder was a public official engaged in the lawful performance of their duties, which would include us as legislators. 8, the victim was protected by a domestic violence order or a no-contact order, and that would apply to a spousal abuse situation or a situation where abuse is already noted and there's a no-contact order given by a court. A defendant who commits any crime other than those 8 that are in that section of the statute is guaranteed to be eligible for parole after 20 years. Because we do have the death penalty in Kentucky, I thought it would be prudent to study the history of how the death penalty has been applied in real life, the practical use of it out in the real world. What I found is it's very rarely used anymore. It's only been given as a sentence 3 times since 2007, and in fact, since we switched to this statutory framework of the aggravating circumstances and the mitigating circumstances, it's in 2012. It's only been sentenced 1 time. There's only been 3 actual executions since 1960. The most recent was in 2008, and it was a very sad case in Boone County where the man pled guilty and asked to waive all his appeals and to be sentenced to death and executed as quickly as possible, which is very sad. The death penalty has faded as a sentence that is given. And I understand there is a valuable conversation to be had, and maybe one day we will have that on whether it should be abolished or not. But I want to say that this bill is not what that is. That's not the discussion we are having today. This is really more about giving prosecutors the tools necessary to get longer penalties for those that kill our children. It is a difficult conversation to have. I wouldn't stand here today presenting this bill if there wasn't a reason to do so. It is named Kimber's Law, and there's a reason why. That reason is Kimber Collins. And I'll quickly tell the story of her, of one of the most horrible cases I encountered as a prosecutor. She was a 3-year-old, beautiful, healthy little girl in McCreary County. On August 21st, 2019, she was beaten to death over the course of 3 hours by her mother's boyfriend. When the paramedics arrived, she had a Glasgow coma score of 3, and that is the worst it gets. She was on a ventilator for 3 days before her mother had to make the decision to pull the plug. And under Kentucky law, when she arrived at the hospital, she was legally dead. She did not deserve to live like that, and she did not deserve to die like that. And under Kentucky law, we had to prosecute the man who did this horrible, heinous act under the statutory framework of a Class A felony without the aggravating circumstance. No matter what proof we had, no matter what evidence we had, no matter what we showed the jury or what the jury thought, we could not guarantee to Kimber's mother that this man would not be released from prison one day. I think that's a disservice to the most vulnerable victims in our Commonwealth. And unfortunately, after I filed this bill about a week later, the same thing happened in Whitley County. A 2-year-old beaten to death, again by mom's boyfriend. Mr. Speaker and ladies and gentlemen of the House, I call on us to add the most vulnerable of us to this list of aggravating circumstances. Other states that have this statutory framework, they've included children, and I think it's time that Kentucky does the same. Mr. Speaker, I'm open to discussion and questions. I'd be happy to address any questions. And if there is none, I would move for passage.